In cases with multiple negligent defendants, juries decide how much fault to assign each. But legal factors, like joint and several liability, could affect the amount of damages each defendant pays. Should juries be informed of that? Lacy v. CSX Transportation addressed that question. Cacoe Sullivan drove with her fiancé, Richard Brooks, and her mother, Tanya Lacy, down 3rd Avenue, which ran parallel to two railroad tracks owned by CSX Transportation. Up ahead, Sullivan saw that the warning lights and gates of a railroad crossing she planned to cross had activated because of a slow-moving train that was several hundred feet away. Believing she had plenty of time to beat the train, Sullivan ran the stop sign at the intersection and drove around the lowered gate onto the tracks. But a fast-moving train on the second track struck the car, injuring Lacy and paralyzing Brooks. Lacy and Brooks sued Sullivan and CSX, arguing that CSX was negligent for allowing slow and fast trains to approach the crossing simultaneously. Witnesses testified that locals often drove around the lowered gate because it activated long before slow trains came within a dangerous proximity. At closing, over Lacy's and Brooks's objections, the judge allowed CSX's attorney to tell the jury that Lacy would demand the entire award from CSX because she wouldn't want to collect from her daughter, Sullivan, and that assigning even 1% liability to CSX would be the same as finding it solely liable. Ultimately, the jury assigned 1% negligence to CSX, Lacy, and Brooks, respectively, and 97% to Sullivan, finding her negligence as the sole proximate cause of the accident. Accordingly, the trial court entered judgment in CSX's favor. Lacy and Brooks appealed to the West Virginia Supreme Court of Appeals.